Before we get you back in court in Wisconsin, let's bring in national trial lawyer Michael Jaafar. Michael, always great to have you on with us. Thank you for joining. Let's talk about that little short video that we all just watched together. The first time we've seen that video, and it looks like the defendant can be seen wielding the knife. I would suggest what I saw was kind of going after people potentially. Does this change the case and put it back on the state to be really proving that perhaps this wasn't all self-defense?
Judge Ashley, when I saw that video and when I saw the other video from the other bystander yesterday, all I kept thinking about as a defense attorney, you wish that your client had used a gun in that instance, not a knife, because a gun would have been so instantaneous. Wielding the knife and being in that situation, you linger for so much longer, and there's so much opportunity for retreat. In law school, we all learned that when you are in a situation where you're defending yourself, it's no longer self-defense if you have the opportunity for retreat. Some states don't abide by that, but when you're with a knife, the chances for retreat are a lot larger than, with a gun, right? Because here he's in this situation, he's wielding this knife, there's a bunch of people around him, he clearly lost his temper. With a gun, he could have said, look, it was instantaneous, I squeezed the trigger, I was in fear for my life. It's harder with a knife. So I think by seeing this footage, I feel like wielding the knife and lingering as long as he did is not going to bode well for him. I still think this looks like a better case for self-defense, but it's not as good.
Yeah, and I want to say, as far as that duty to retreat in Wisconsin, basically the jury can consider it whether he had the opportunity to retreat as part of their determination of reasonableness. So, it's not that he has a duty to retreat, but they can consider the fact that he had the opportunity to, which I think a couple of times he definitely does. So that's going to be a part of the calculation. But I want to go back to that video because it seemed to me, again, that he was going after people, Michael. And if he's going after people, there's a possibility here where there could be a split verdict. So what I'm saying is maybe in the first instance, the first person, he was justified in thinking that my life is under threat. Then he begins to get up and go after people. Now, I understand adrenaline and all that, but will the jury understand it? So he could be convicted of attempted murder of some of the people, but maybe not the murder of the one kid who maybe he felt, put his life in danger.
I didn't think about it until you just said it, where it's not exactly all the same. I mean, you're right. He could be acquitted for attempting to murder, for the murder of the actual kid he murdered, but convicted of attempted murder for other people. That's actually a great point. The testimony yesterday, there was a kid on the stand that testified that he saw him basically get knocked out and go into the water when this was on cross-examination with the defendant's attorney, where he said he was knocked out, his face went underwater, and he looked like he was in bad shape, and we really did a number on him. And that testimony happened before he committed any of the murder. So I think that right there is an anchor for the defense, for them to say everything else that happened after that, he had no idea who was behind him. He lingered. Had he retreated, somebody would have came up behind him, knocked him out again, and taken the gun from him. So the fact that he was already knocked out kind of helps his defense in saying everything else after that was all self-defense. But that's a good point. Yeah, he could get acquitted of the murder and get convicted of attempted murder that happened maybe 3 minutes later.
Yeah, it is a possibility.
Sure is.
And that's not minutes, Mike. It would be seconds. Apparently, like, if you see the video, he kind of stands around for a couple of seconds, and then people are running away from him. He's going after them. But you're right. The whole mob around him, he could certainly be justified in feeling everyone around him is a danger to him. So, welcome back, folks. We're going to get you back to court in just a moment, but I want to first bring in national trial lawyer Michael Jaafar. And Mike, I want to get your thoughts on Mr. Davis's testimony, Larry and Davis. Judge and I both feel like the testimonial part is probably not even going to be considered. The defense did a great job of sort of showing he didn't quite really remember what he thought he remembered. And again, as I said, I don't think it was malicious in any way. I just think things changed in his mind and didn't make much sense.
I find myself in a position where I'm envying the defense, because anytime that the prosecution's case against your client is based on a half dozen of teenagers and kids who are in various stages of drunkenness, you can make Swiss cheese of the testimony and you can poke a lot of holes. And that's basically what the defense are doing. I mean, they're doing awesome cross-examination, but it's kind of easy. That's why I envy them a little bit, because this is the type of, you have a buffet of options as a defense attorney when, the witnesses against you are in this type of a position. So I don't believe there was anything nefarious about Mr. Davis's testimony. I think he was a nice kid. He was a bystander, but he's a civilian, not a professional. When you have professional witnesses like examiners and experts, these are people who are tried and true. They've done this before. They get paid. They have an hourly rate. They have a CV. These are people who are ready for cross-examination. Civilians are not ready for cross-examination, and you're seeing it now.
Well, and here's the other thing. What is the demeanor of the defendant going to be like on the stand? That's going to make a huge difference, too.